Title 16 of the New Civil Code of the Philippines deals with pledge, mortgage, and anticrisis. Chapter 1, Provisions Common to Pledge and Mortgage. Article 2085. The following requisites are essential to the contracts of pledge and mortgage. 1. That they be constituted to secure the fulfillment of a principal obligation. 2. That the pledger or mortgager be the absolute owner of the thing pledged or mortgaged. 3. That the persons constituting the pledge or mortgage have the free disposal of their property, and in the absence thereof, that they be legally authorized for the purpose. Third persons who are not parties to the principal obligation may secure the latter by pledging or mortgaging their own property. Article 2085 enumerates the essential requisites common to pledge and mortgage. The first of which is that they be constituted to secure the fulfillment of a principal obligation. Pledge and mortgage are purely accessory contracts like guarantee. They cannot exist without a valid obligation. However, they may guarantee a voidable, unenforceable, or natural obligation. The second common requisite is that the pledger or mortgager be the absolute owner of the thing pledged or mortgaged. It is essential that the contract be constituted only by the absolute owner of the thing pledged or mortgaged, or at least by the pledger or mortgager with the authority or consent of the owner of the property pledged or mortgaged. A pledge or mortgage constituted by an impostor is void, and the pledger or mortgagee in such a case acquires no right whatsoever in the property. A pledge or mortgage executed by one who is not the owner of the property pledged or mortgaged is without legal existence, and registration cannot validate it. Thus, a mortgage executed before the mortgager became the owner of the property is void and ineffective. The same is true with future property. Future property cannot be pledged or mortgaged. The third common requisite between pledge and mortgage is that the persons constituting the pledge or mortgage have the free disposal of their property, and in the absence thereof, that they be legally authorized for the purpose. The act of pledging or mortgaging is an act of strict ownership involving as it does an alienation or transmission of real rights and property. Hence, the pledger or mortgager must have the capacity or authority to dispose of the property. Free disposal of the property means that the property must not be subject to any claim of a third person, and capacity to dispose of property means that the pledger or mortgager has the capacity or the authority to make the disposition of the property. The third paragraph of Article 2085 says that third persons who are not parties to the principal obligation may secure the latter by pledging or mortgaging their own property. This means that it is not necessary that the principal debtor should always be the pledger or mortgager, as in the case of accommodation pledge or mortgage. It is not necessarily void simply because the accommodation pledger or mortgager did not benefit from the same. As long as valid consent was given, the fact that the loan was solely for the benefit of the debtor would not invalidate the pledge or mortgage. Article 2086. The provisions of Article 2052 are applicable to a pledge or mortgage. Article 2052 says, a guarantee cannot exist without a valid obligation. Nevertheless, a guarantee may be constituted to guarantee the performance of a voidable or an unenforceable contract. It may also guarantee a natural obligation. Therefore, as stated earlier, pledge and mortgage may also be constituted to guarantee the performance of a voidable or an unenforceable contract, or even a natural obligation. Article 2087. It is also of the essence of these contracts that when the principal obligation becomes due, the things in which the pledge or mortgage consists may be alienated for the payment to the creditor. When the obligation becomes due, the creditor is not required to sue to enforce his credit. the pledgee or mortgagee is not obligated to file an independent action for the enforcement of his credit. When the obligation becomes due, the thing pledged or mortgaged may be alienated. This is the essence of pledge and mortgage because they are constituted to secure the fulfillment of a principal obligation. Although this condition is not expressly stated in the contract, it is necessarily implied as an inherent element of the transaction of mortgage or pledge. Article 2088. The creditor cannot appropriate the things given by way of pledge or mortgage, or dispose of them. Any stipulation to the contrary is null and void. If the debtor fails to comply with the obligation at the time it falls due, the creditor is merely entitled to move for the sale of the thing pledged or mortgaged with the formalities required by law in order to collect the amount of his claim from the proceeds. Upon failure of the mortgagor to pay his obligation within the required period, the remedy of the mortgagee is to foreclose the mortgage, and if he wishes to secure a title to the mortgaged property, he can buy it in the foreclosure sale. The pledger's or mortgagor's default does not operate to vest in the pledgee or mortgagee the ownership of the property, for such is against public policy. The creditor in a contract of real security like pledge and mortgage cannot appropriate to himself without foreclosure of the thing held as pledge or under mortgage, nor can he dispose of the same as owner. This prohibition also applies to an immovable, which is the object of the contract of antichrisis. A stipulation whereby the thing pledged or mortgaged or under antichrisis shall automatically become the property of the creditor in the event of non-payment of the debt within the term fixed is known as pactum commissorium or pacto commissorio, which is forbidden by law and declared null and void. By such a stipulation, the creditor would be able to acquire ownership of the property given as security without need of public sale or foreclosure required by law. There are two requisites or elements for pactum commissorium to exist, namely, 1. There should be a pledge, mortgage, or antichrisis of property by way of security for the payment of the principal obligation, and 2. There should be a stipulation for an automatic appropriation by the creditor of the property in the event of non-payment of the obligation within the stipulated period. It is immaterial that the questioned stipulation was voluntarily and freely entered into. Pactum commissorium is void for being prohibited by law. What is prohibited by Article 2088 in connection with Pacto Commissorio is the automatic appropriation by the creditor of the thing pledged or mortgaged upon failure of the debtor to pay his debt within the period agreed upon by virtue of authority or right previously given to the creditor. Article 2089. A pledge or mortgage is indivisible even though the debt may be divided among the successors in interest of the debtor or of the creditor. Therefore, the debtor's heir who has paid a part of the debt cannot ask for the proportionate extinguishment of the pledge or mortgage as long as the debt is not completely satisfied. Neither can the creditor's heir who received his share of the debt return the pledge or cancel the mortgage to the prejudice of the other heirs who have not been paid. From these provisions is excepted the case in which, there being several things given on mortgage or pledge, each one of them guarantees only a determinate portion of the credit. The debtor in this case shall have a right to the extinguishment of the pledge or mortgage as the portion of the debt for which each thing is especially answerable is satisfied. Every portion of the property pledged or mortgaged is answerable for the whole obligation as soon as it falls due. When several things are pledged or mortgaged to secure the same debt in its entirety, all of them are liable for the totality of the debt and the creditor does not have to divide his action by distributing the debt among the various things pledged or mortgaged. Even when only a part of the debt remains unpaid, all the things are liable for such balance. The debtor cannot ask for the release of one or some of the several properties pledged or mortgaged or any portion thereof, or the proportionate extinguishment of the pledge or mortgage unless and until the debt secured has been fully paid. The debtor's heir who has paid a part of the debt cannot ask for the proportionate extinction of the pledge or mortgage, nor can the creditor's heir who has received his share of the debt return the pledge or cancel the mortgage if the debt is not completely satisfied. Article 2090. The indivisibility of a pledge or mortgage is not affected by the fact that the debtors are not solidarily liable. Article 2091. The contract of pledge or mortgage may secure all kinds of obligations, be they pure or subject to a suspensive or resolutory condition. All kinds of obligations can be secured by pledge or mortgage. Any kind of obligation, whether pure or conditional, may be secured by a contract of pledge or mortgage. The same applies in guarantee, which may also secure a conditional obligation. The pledge agreement may stipulate that the pledge will also stand as security for any future advancements or renewals thereof that the pledger may procure from the pledgee. Article 2092. A promise to constitute a pledge or mortgage gives rise only to a personal action between the contracting parties without prejudice to the criminal responsibility incurred by him who defrauds another by offering in pledge or mortgage as unencumbered things which he knew were subject to some burden, or by misrepresenting himself to be the owner of the same. Promise to constitute pledge or mortgage creates no real right. A promise to constitute a pledge or mortgage, if accepted, gives rise only to a personal right binding upon the parties and creates no real right in the property. In other words, what exists is only a right of action to compel the fulfillment of the promise, but there is no pledge or mortgage yet. It has been held that the creditor can enforce an agreement to constitute a mortgage together with the right to recover the indebtedness, they being in no wise inconsistent with each other. Criminal responsibility of pledger or mortgagor. Under the revised penal code, estafa is committed by a person who, pretending to be the owner of any real property, shall convey, sell, encumber, or mortgage the same, or knowing that the real property is encumbered, shall dispose of the same as unencumbered. It is essential that the fraud or deceit be practiced upon the vendee at the time of the sale. Chapter 2, Pledge. Articles 2093 to 2123. Pledge is either voluntary or conventional or legal. Voluntary or conventional pledge is one which is created by agreement of the parties, and legal pledge is one which is created by operation of law. Examples of legal pledge are the ones referred to in Articles 546, 1731, and 1994. Article 2093. In addition to the requisites prescribed in Article 2085, it is necessary, in order to constitute the contract of pledge, that the thing pledged be placed in the possession of the creditor or of a third person by common agreement. Characteristics of the contract of pledge. 1. It is a real contract, because it is perfected by the delivery of the thing pledged by the debtor, who is called the pledger, to the creditor, who is called the pledgee, or to a third person by common agreement. 2. It is an accessory contract because it has no independent existence of its own. 3. It is a unilateral contract because it creates an obligation solely on the part of the creditor to return the things subject thereof upon the fulfillment of the principal obligation. And 4. It is a subsidiary contract because the obligation incurred does not arise until the fulfillment of the principal obligation which is secured. Article 2094. All movables which are within commerce may be pledged, provided they are susceptible of possession. Article 2095. Incorporeal rights, evidenced by negotiable instruments, bills of lading, shares of stock, bonds, warehouse receipts, and similar documents may also be pledged. The instrument proving the right pledged shall be delivered to the creditor and, if negotiable, must be endorsed. Articles 2094 and 2095 tell us what may be pledged. A pledge is confined and limited to personal property, and it cannot be extended or made to apply to real property. Article 2096. A pledge shall not take effect against third persons if a description of the thing pledged and the date of the pledge do not appear in a public instrument. Even if all the essential requisites provided in Articles 2085 and 2093 are present, the contract of pledge is not effective against third persons unless, in addition to the delivery of the thing pledged, it is embodied in a public instrument, wherein it shall appear the description of the thing pledged and the date of the pledge. The object is to forestall fraud, because a debtor may attempt to conceal his property from his creditors when he sees it in danger of execution by simulating a pledge thereof with an accomplice. Article 2097. With the consent of the pledgee, the thing pledged may be alienated by the pledger or owner, subject to the pledge. The ownership of the thing pledged is transmitted to the vendee or transferee as soon as the pledgee consents to the alienation, but the latter shall continue in possession. Alienation by the pledger of the thing pledged. The pledger retains his ownership of the thing pledged. He may therefore sell the same, provided the pledgee consents to the sale. As soon as the pledgee gives his consent, the ownership of the thing pledged is transferred to the vendee, subject to the rights of the pledgee, namely, that the thing sold may be alienated to satisfy the obligation, and that the pledgee must continue in possession during the existence of the pledge. But the pledge would not bind or adversely affect third persons unless Article 2096 has been followed. Article 2096 refers to the requirement that the pledge must be embodied in a public instrument, wherein it shall appear the description of the thing pledged and the date of the pledge. Article 2098. The contract of pledge gives a right to the creditor to retain the thing in his possession or in that of a third person to whom it has been delivered until the debt is paid. Right of pledgee to retain thing pledged. As has been stated, the possession of the pledgee constitutes his security. Hence, the debtor cannot demand for its return until the debt secured by it is paid. But the right of retention is limited only to the fulfillment of the principal obligation for which the pledge was created. Article 2099. The creditor shall take care of the thing pledged with the diligence of a good father of a family. He has a right to the reimbursement of the expenses made for its preservation and is liable for its loss or deterioration in conformity with the provisions of this code. Obligation of pledgee to take due care of thing pledged. Upon fulfillment of the principal obligation, the pledgee must return the thing pledged. Having possession of the property, he has the obligation to take care of the same with the diligence of a good father of the family. He is, however, entitled to reimbursement of the expenses incurred for its preservation. In case of the loss or deterioration of the thing pledged due to fortuitous event, the pledgee cannot be held responsible, but he is liable for loss or deterioration by reason of fraud, negligence, delay, or violation of the terms of the contract. Article 2100. The pledgee cannot deposit the thing pledged with a third person unless there is a stipulation authorizing him to do so. The pledgee is responsible for the acts of his agents or employees with respect to the thing pledged. Obligation of pledgee not to deposit the thing pledged with another person. While the pledgee is entitled to retain the possession of the thing pledged until the debt is paid, he is not, however, authorized to transfer possession of the thing to a third person. The prohibition is necessary for the protection of the pledger or the owner of the thing pledged. The exception is when there is a stipulation authorizing him to do so. The pledgee is responsible for the acts of his agents or employees with respect to the thing pledged because their acts are, in legal effect, deemed to be his. Article 2101. The pledger has the same responsibility as a bailor in commodatum in the case under Article 1951. Article 1951 says, the bailor who, knowing the flaws of the thing loaned, does not advise the bailee of the same, shall be liable to the latter for the damages which he may suffer by reason thereof. Article 2102. If the pledge earns or produces fruits, income, dividends, or interests, the creditor shall compensate what he receives with those which are owing him. But if none are owing him, or in so far as the amount may exceed that which is due, he shall apply it to the principal. Unless there is a stipulation to the contrary, the pledge shall extend to the interest and earnings of the right pledged. In case of a pledge of animals, their offspring shall pertain to the pledger or owner of animals pledged, but shall be subject to the pledge if there is no stipulation to the contrary. Right of pledgee to compensate earnings of pledge with debt. The pledgee has no right to use the thing pledged or to appropriate the fruits thereof without the authority of the owner. But the pledgee can apply the fruits, income, dividends, or interest earned or produced by the thing pledged to the payment of the interest if owing, and thereafter to the principal of his credit. Unless there is a stipulation to the contrary, the interest and earnings of the right pledged and, in case of animals, their offsprings are included in the pledge. Article 2103. Unless the thing pledged is expropriated, the debtor continues to be the owner thereof. Nevertheless, the creditor may bring the actions which pertain to the owner of the thing pledged in order to recover it from or defend it against a third person. Right of pledgee against third persons. Except as provided in Article 2112, which we will discuss shortly, the pledger remains the owner of the property pledged. The creditor to whom the property pledged has been delivered is obliged to take care of it with the diligence of a good father of a family. He is authorized to bring such action as pertaining to the owner in order to recover it or defend it against claims of third persons. Furthermore, unless given the right, the creditor might be prejudiced by the negligence of the owner. The right of the pledgee is a real right enforceable against third persons, but it is necessary that the contract of pledge be embodied in a public instrument which shall contain a description of the thing pledged and the date of the pledge. Article 2104. The creditor cannot use the thing pledged without the authority of the owner, and if he should do so or should misuse the thing in any other way, the owner may ask that it be judicially or extrajudicially deposited. When the preservation of the thing pledged requires its use, it must be used by the creditor but only for that purpose. Obligation of pledgee not to use the thing pledged. The pledgee who is in possession of the thing pledged has no right to make use of it without permission from the owner. This is the same rule in deposit. It is in consequence of the fact that the pledger, in parting with his property, transmits only possession but not ownership. If, however, the thing pledged is of such a character that use is necessary in properly caring for it, then it becomes his duty to use it so that it will not suffer from its disuse. If from the use of the property profits are derived, the pledgee must account therefore to the pledger, and apply the net proceeds of such use to the payment of his claim. In the following cases, the owner may ask that the thing pledged be deposited judicially or extrajudicially. 1. If the creditor uses the thing without authority. 2. If he misuses the thing in any other way. Or 3. If the thing is in danger of being lost or impaired because of the negligence or willful act of the pledgee. Article 2105. The debtor cannot ask for the return of the thing pledged against the will of the creditor unless and until he has paid the debt and its interest with expenses in a proper case. Right of pledger to demand return of thing pledged. The thing pledged stands as security for the fulfillment of the pledger's obligation. Hence, he cannot ask for its return until said obligation is fully paid, including interest due thereon and expenses incurred for its preservation. Prescription will not begin to run on the action to demand the return of the thing pledged while the obligation subsists. Neither will the possession of the pledgee as such ripen into ownership by prescription, because such possession is not in the concept of an owner. As an exception to this rule, the pledger is allowed to substitute the thing pledged which is in danger of destruction or impairment with another thing of the same kind and quality. Article 2106. If through the negligence or willful act of the pledgee, the thing pledged is in danger of being lost or impaired, the pledger may require that it be deposited with a third person. Right of pledger to ask for deposit of thing pledged. The pledgee has the duty to preserve the thing pledged with the diligence of a good father of a family. If the thing should be exposed to loss or impairment through the negligence or willful act of the pledgee, the pledger may demand that it be deposited with a third person. The pledger may also require such deposit should the pledgee use the thing without authority or misuse it in any other way. Article 2107. If there are reasonable grounds to fear the destruction or impairment of the thing pledged without the fault of the pledgee, the pledger may demand the return of the thing upon offering another thing in pledge, provided the latter is of the same kind as the former and not of inferior quality, and without prejudice to the right of the pledgee under the provisions of the following article. The pledgee is bound to advise the pledger without delay of any danger to the thing pledged. Right of pledger to substitute thing pledged. Two remedies are actually granted by this article, to wit, to the pledger, the right to demand the return of the thing pledged upon offering another thing in pledge, and to the pledgee, the right to cause the same to be sold at a public sale. The following are the requisites for the application of this article. 1. The pledger has reasonable grounds to fear the destruction or impairment of the thing pledged. 2. There is no fault on the part of the pledgee. 3. The pledger is offering in place of the thing another thing in pledge which is of the same kind and quality as the former. And 4. The pledgee does not choose to exercise his right to cause the thing pledged to be sold at public auction. Article 2108. If, without the fault of the pledgee, there is danger of destruction, impairment, or diminution in the value of the thing pledged, he may cause the same to be sold at a public sale. The proceeds of the auction shall be a security for the principal obligation in the same manner as the thing originally pledged. Right of pledgee to cause sale of thing pledged. The pledgee's right to have the thing pledged sold at public sale, granted under this article, is superior to that given to the pledger to substitute the thing pledged under Article 2107. The law says the pledger is given the right without prejudice to the right of the pledgee. The sale must be a public sale. The pledgee shall keep the proceeds of the sale as security for the fulfillment of the principal obligation. In other words, they shall belong to the pledger. Article 2109. If the creditor is deceived on the substance or quality of the thing pledged, he may either claim another thing in its stead or demand immediate payment of the principal obligation. Right of pledgee to demand substitute or immediate payment. This article grants two remedies to the pledgee in case he is deceived as to the substance or quality of the thing pledged. 1. To claim another thing in pledge, and 2. To demand immediate payment of the principal obligation. The remedies are alternative, that is, he is privileged to choose only one and not both. Article 2110. If the thing pledged is returned by the pledgee to the pledger or owner, the pledge is extinguished. Any stipulation to the contrary shall be void. If subsequent to the perfection of the pledge, the thing is in the possession of the pledger or owner, there is a prima facie presumption that the same has been returned by the pledgee. This same presumption exists if the thing pledged is in the possession of a third person who has received it from the pledger or owner after the constitution of the pledge. Extinguishment of pledge by return of thing pledged. One of the essential requisites of pledge is that the object be placed in the possession of the creditor or of a third person by common agreement. Hence, the pledge is extinguished if the object is returned by the pledgee, and this is true notwithstanding any stipulation that the pledge would continue although the pledgee is no longer in possession. The pledge is also extinguished by payment of the debt, by renunciation or abandonment of the pledge, and by the sale of the thing pledged at public auction. The possession by the debtor or owner of the thing pledged subsequent to the perfection of the pledge gives rise to the prima facie presumption that the thing has been returned and, therefore, that the pledge has been extinguished. The presumption may be rebutted by evidence to the contrary, as for example, that the return was merely for the substitution of the thing pledged, or that the thing was stolen and given by the thief to the pledger or owner. There is authority supporting the proposition that the pledgee can temporarily entrust the physical possession of the chattel pledged to the pledger without invalidating the pledge. In such a case, the pledger is regarded as holding the pledged property merely as a trustee for the pledgee. Article 2111. A statement in writing by the pledgee that he renounces or abandons the pledge is sufficient to extinguish the pledge. For this purpose, neither the acceptance by the pledger or owner nor the return of the thing pledged is necessary, the pledgee becoming a depositary. Extinguishment of pledge by renunciation or abandonment. The pledge is a personal right of the pledgee which may be waived. Under this article, the renunciation or abandonment must be in writing to extinguish the pledge, and such renunciation is not conditioned upon the acceptance by the pledger or owner nor upon the return of the thing pledged. The waiver transforms the pledgee into a depositary with the rights and obligations of one. The principal debt, however, is not affected by the waiver of the pledge, but the waiver of the principal obligation carries with it that of the pledge. Under this article, the thing pledged remains in the possession of the pledgee, hence the waiver must be in writing. Under Article 2110, the pledge is extinguished even in the absence of waiver if the thing pledged is returned to the pledger. Other causes of extinguishment of pledge are prescription, loss of the thing, merger, compensation, novation, etc. Article 2112. The creditor to whom the credit has not been satisfied in due time may proceed before a notary public to the sale of the thing pledged. This sale shall be made at a public auction and with notification to the debtor and the owner of the thing pledged in a proper case, stating the amount for which the public sale is to be held. If at the first auction the thing is not sold, a second one with the same formalities shall be held, and if at the second auction there is no sale either, the creditor may appropriate the thing pledged. In this case, he shall be obliged to give an acquittance for his entire claim. Right of pledgee to cause sale of thing pledged. One of the essential requisites of pledge is that the object pledged may be alienated for the payment to the creditor when the principal obligation becomes due. The formalities required for such sale under the above article are as follows. 1. The debt is due and unpaid. 2. The sale must be at public auction. 3. There must be notice to the pledger and owner stating the amount due. And 4. The sale must be made with the intervention of a notary public. The pledgee may appropriate the thing pledged if after the first and second auctions the thing is not sold. This is an exception to the prohibition against pacto commissorio. If the creditor appropriates the thing, it shall be considered as full payment for his entire claim. He is thus obliged to give an acquittance for the same. The debtor is not entitled to the excess in case the value of the thing pledged is more than the principal obligation. Article 2113. At the public auction, the pledger or owner may bid. He shall moreover have a better right if he should offer the same terms as the highest bidder. The pledgee may also bid, but his offer shall not be valid if he is the only bidder. Article 2113. At the public auction, the pledger or owner may bid. He shall moreover have a better right if he should offer the same terms as the highest bidder. The pledgee may also bid, but his offer shall not be valid if he is the only bidder. Right of pledger and pledgee to bid at public sale. If the debt is not paid and a public sale takes place, both the pledger and the pledgee may bid. The pledger shall be preferred if he offers the same terms as the highest bidder, and the rule is just, considering that all the things belong to him. To avoid fraud, the pledgee is not allowed to acquire the thing pledged if he is the only bidder. Article 2114. All bids at the public auction shall offer to pay the purchase price at once. If any other bid is accepted, the pledgee is deemed to have received the purchase price as far as the pledger or owner is concerned. All bids, including that of the pledger, must be for cash. If the pledgee accepts a bid other than for cash, the pledger or owner has the right to consider that the pledgee has received the purchase price in cash. Article 2115. The sale of the thing pledged shall extinguish the principal obligation, whether or not the proceeds of the sale are equal to the amount of the principal obligation, interest and expenses in a proper case. If the price of the sale is more than said amount, the debtor shall not be entitled to the excess unless it is otherwise agreed. If the price of the sale is less, neither shall the creditor be entitled to recover the deficiency, notwithstanding any stipulation to the contrary. Effect of sale of thing pledged. The sale of the thing pledged extinguishes the principal obligation whether the price of the sale is more or less than the amount due. If the price of the sale is more than the amount due to the creditor, the debtor is not entitled to the excess unless the contrary is provided. In the same way, if the price of the sale is less, neither is the creditor entitled to recover the deficiency. A contrary stipulation is void. The creditor may sue on the principal obligation instead of electing to sell the thing pledged, and in such case he may recover the deficiency from the debtor. Article 2116. After the public auction, the pledgee shall promptly advise the pledger or owner of the result thereof. The purpose of this article is to enable the pledger or owner to take steps for the protection of his rights where he has reasonable grounds to believe that the sale was not an honest one. Article 2117. Any third person who has any right in or to the thing pledged may satisfy the principal obligation as soon as the latter becomes due and demandable. Right of third person to satisfy the obligation. As a general rule, the creditor is not bound to accept payment or performance by a third person who has no interest in the fulfillment of the obligation. Under this article, a third person who has any right in or to the thing pledged may pay the debt as soon as it becomes due and demandable, and the creditor cannot refuse to accept the payment. Article 2118. If a credit which has been pledged becomes due before it is redeemed, the pledgee may collect and receive the amount due. He shall apply the same to the payment of his claim and deliver the surplus, should there be any, to the pledgor. Article 2119. If two or more things are pledged, the pledgee may choose which he will cause to be sold unless there is a stipulation to the contrary. He may demand the sale of only as many of the things as are necessary for the payment of the debt. Right of pledgee to choose which of several things pledged shall be sold. The right of choice given to the pledgee as to which of the things pledged she shall cause to be sold is limited only by stipulation. After sufficient property has been sold to satisfy the obligation plus interests and expenses, no more shall be sold. Article 2120. If a third party secures an obligation by pledging his own movable property under the provisions of Article 2085, he shall have the same rights as a guarantor under Articles 2066 to 2070 and Articles 2077 to 2081. He is not prejudiced by any waiver of defense by the principal obligor. Article 2085. The following requisites are essential to the contracts of pledge and mortgage. 1. That they be constituted to secure the fulfillment of a principal obligation. 2. That the pledgor or mortgagor be the absolute owner of the thing pledged or mortgaged. And 3. That the persons constituting the pledge or mortgage have the free disposal of their property, and in the absence thereof, that they be legally authorized for the purpose. Third persons who are not parties to the principal obligation may secure the latter by pledging or mortgaging their own property. Article 2066. The guarantor who pays for a debtor must be indemnified by the latter. The indemnity comprises 1. The total amount of the debt. 2. The legal interest thereon from the time the payment was made known to the debtor, even though it did not earn interest for the creditor. 3. The expenses incurred by the guarantor after having notified the debtor that payment had been demanded of him. And 4. Damages if they are due. Article 2067. The guarantor who pays is subrogated by virtue thereof to all the rights which the creditor had against the debtor. If the guarantor has compromised with the creditor, he cannot demand of the debtor more than what he has really paid. Article 2068. If the guarantor should pay without notifying the debtor, the latter may enforce against him all the defenses which he could have set up against the creditor at the time the payment was made. Article 2069. If the debt was for a period and the guarantor paid it before it became due, he cannot demand reimbursement of the debtor until the expiration of the said period unless the payment has been ratified by the debtor. Article 2070. If the guarantor has paid without notifying the debtor, and the latter, not being aware of the payment, repeats the payment, the former has no remedy whatever against the debtor but only against the creditor. Nevertheless, in case of a gratuitous guarantee, if the guarantor was prevented by a fortuitous event from advising the debtor of the payment, and the creditor becomes insolvent, the debtor shall reimburse the guarantor for the amount paid. Article 2077. If the creditor voluntarily accepts immovable or other property in payment of the debt, even if he should afterwards lose the same through eviction, the guarantor is released. Article 2078. A release made by the creditor in favor of one of the guarantors without the consent of the others benefits all to the extent of the share of the guarantor to whom it has been granted. Article 2079. An extension granted to the debtor by the creditor without the consent of the guarantor extinguishes the guarantee. The mere failure on the part of the creditor to demand payment after the debt has become due does not of itself constitute any extension of time referred to herein. Article 2080. The guarantors, even though they be solidary, are released from their obligation whenever by some act of the creditor they cannot be subrogated to the rights, mortgages, and preference of the latter. Article 2081. The guarantor may set up against the creditor all the defenses which pertain to the principal debtor and are inherent in the debt, but not to those that are personal to the debtor. Article 2121. Pledges created by operation of law, such as those referred to in Articles 546, 1731, 1994, are governed by the foregoing articles on the possession, care, and sale of the thing as well as on the termination of the pledge. However, after payment of the debt and expenses, the remainder of the price of the sale shall be delivered to the obligor. Pledge created by operation of law. Article 546. Necessary expenses shall be refunded to every possessor, but only the possessor in good faith may retain the thing until he has been reimbursed therefor. Useful expenses shall be refunded only to the possessor in good faith, with the same right of retention, the person who has defeated him in the possession having the option of refunding the amount of the expenses or of paying the increase in value which the thing may have acquired by reason thereof. Article 1731. He who has executed the work upon a movable has a right to retain it by way of pledge until he is paid. Article 1994. The depositary may retain the thing in pledge until the full payment of what may be due him by reason of the deposit. Article 2122. A thing under a pledge by operation of law may be sold only after demand of the amount for which the thing is retained. The public auction shall take place within 1 month after such demand. If without just grounds the creditor does not cause the public sale to be held within such period, the debtor may require the return of the thing. Article 2123. With regard to pawnshops and other establishments which are engaged in making loans secured by pledges, the special laws and regulations concerning them shall be observed, and subsidiarily the provisions of this title. Presidential Decree Number 114 regulates the establishment and operation of pawnshops. This is the end of the provisions applicable only to pledge. Real mortgage will follow.